right, Chair, we're live.
All right, good morning. This is Chair Douglas. We will call this meeting to order. If we can have our official roll call.
Great, thank you. Member Dennis Nylander.
Here.
Member Rihanna Durrett.
Present.
Member Brian Young.
Here.
Great, and Member Merritt will not be attending today. And Chair Michael Douglas.
Here.
Great. Deputy Bala, can you please confirm that we have complied with the open meeting law requirements?
We have, sir.
Thank you. So Chair, with your approval, we can get going and move on to agenda item number 1, which is public comment.
All right, having a quorum, if we can have our public comment, we're going to take our in-person or recorded first.
Great, we'll do in person. If there's anyone here in Las Vegas wishing to provide public comment today, please come up to the podium. State your name for the record. Please keep your remarks to 3 minutes.
Good morning. Good morning. My name is Paul Michael Burgess. I'm a business owner here in Las Vegas, city of Las Vegas. To the Honorable Chairman Michael Douglas, Executive Director Tyler Klimas, and the distinguished board members. I am the owner of a small business here in Las Vegas. I'm here in the capacity today as customer success manager and software designer for a cybersecurity application, mobile application company. My public comment today speaks to national public safety and health in the cannabis industry. October 15, 2021, Xavier Becerra, Secretary of Health and Human Services under Section 319 of the Public Health Service Act reaffirmed continued HHS national public health emergency in the U.S. October 16th, FDA released cannabis-derived products data acceleration plan, also called as DAP, looking for new technologies and partners to help with the nation with this emergency public health safety. February 20th, 2021, July 8th, 2021, November 5th, 2021, the CCB posted public safety notices, bulletins advising consumers and patients to avoid or take caution consuming cannabis products listed. This emergency public safety notification was posted to the CCB website and notifications to people subscribed to CCB's email. Days later, published through public news outlets. Not only is this inadequate for emergency public health and safety notifications information meant to save lives, it is in violation of federal statutes, leaves the CCB open to civil suits. I come before the board to present a solution to this national public safety problem and offer a demo to the board and the authorizing administrator as soon as possible. Verdun Health Tech, founded by a minority woman service disabled veteran, has been directly in the reporting of adverse events through mobile applications since 2016. This mobile application was MIT Medical Hackathon 2018 category winner. Research and DOJ data shows that federal, state, and local procurement is built off corruption, discrimination, collusion, and cronyism. 40% of minority businesses are in the health and service industry, and about a third of Black-owned firms are in the health care and service industry. Of the $23 billion given by Congress in the CARES Act, Black-owned businesses in the health and service businesses received 0.17% in funding. All government contracts issued through the government procurement, Black businesses receive less than 5% every year. With firsthand knowledge and understanding of government procurement and government models of hurry up and wait, from tragedies of 9/11 to Travis Scott's Astro World, the government has shown a pattern of willfully disregarding information, tools, services that are made aware that could save lives to keep up with its cronyism until there's multiple casualties. Notice of action. I do not bring this to be brazen to the board and its members. notice of action with the understanding of ethics, federal statutes. I have notified the CCB in real time with federal documents pertaining to national public health and safety to prevent in the cannabis industry. The Nevada legislation has passed laws and processes for this emergency public health situation. 14 days from this day of November 16th, with no response from the administrator of the CCB or the CCB, I will file a federal civil complaint on behalf of the citizens in the state of Nevada. About a third of all Black-owned firms. Okay. I end this with God bless our policemen and women, our troops, our veterans, and God bless we the people. Thank you.
Thank you.
I would like to leave this for the board and my business ID. Thank you.
Thank you. Is there anyone else in Las Vegas wishing to provide public comment at this time? Great, we'll go up to Carson City. Chief Gilbert, is there anyone in Carson City wishing to provide public comment?
I see no public comment in Carson City.
Thank you. With that, Chair, we can move on to agenda item number 2. This is the meeting minutes. Back to you.
Item 2 is meeting minutes, consideration for approval of the October 26, 2021 Cannabis Compliance Board meeting minutes. They've been provided to us prior to the meeting. If there's corrections or additions or a motion for acceptance, if we can have that so made.
Mr. Chairman, this is Member Nylander. I would move for approval of the October 26, 2021 minutes.
We have a motion for approval. Do we have a second to that motion?
This is Member Young. I'll second that.
Thank you, Member Young, for the second. Any discussion or corrections to be noted? Hearing none, all in favor of the approval of the minutes, please say aye.
Aye.
Aye. Any nays? Any abstentions? Motion carries. That would move us to item number 3, our consent agenda as to complaints.
Thank you, Chair. Item 3A on the agenda concerns 3 complaints today for disciplinary action pursuant to NRS 678A 510. The Attorney General has reviewed these violations and has recommended proceeding with disciplinary action. As we did at our prior meetings, I'll be requesting board approval to proceed with each of these 3 disciplinary actions. If approved, I'll then authorize service of the complaints. As service is now in the hands of the Executive Director, we're not required to immediately serve all complaints today. So once the board has approved, or if the board approves, proceeding with disciplinary action, service will proceed within a reasonable time. And if approved, the complaints will be filed and served within approximately 1 to 3 weeks. Once they're out for service, CCB will post them online. So I'll now present the violations alleged and request the board vote to authorize proceeding with disciplinary action against these 3 respondents. As to respondent A, complaint will allege violations of the following statutes and regulations: NRS 678B, NRS 678C 440, NCCR Regulation 4, and NCCR Regulation 6. As to respondent B, the complaint will allege violations of the following statutes and regulations: NCCR Regulation 4. And as to respondent C, the complaint will allege violations of NRS 678B, NCCR Regulation 4, NCCR Regulation 5, and NCCR Regulation 6. With that, Chair, I'll turn the item back over to you.
As item number 3, consent agenda as to the complaints, the 3 set for issuance with approval of the board. We are doing this pursuant to the Nevada revised statutes. We have not seen the complaints. We've heard for the first time the blind statements. Do we have a motion for approval for service of?
Mr. Chairman, this is Member Nylander. I would move for approval of agenda item number 3A, items 1 through 3, as stated on the agenda, with approval to proceed with disciplinary action for each of those items.
Thank you. Do we have a second as to that?
This is Member Young. I'll second that.
It's been moved and seconded. Any discussion, additional discussion or statements? Hearing none, all in favor of service of complaints pursuant to the as stated in the motion, please say aye.
Aye.
Aye. Any dissents? Any abstentions? Hearing none, the motion carries. That would move us to item number 4, consideration for approval of proposed settlement agreements to resolve disciplinary actions. We have 3 items.
Thank you, Chair. We will now go to Senior Deputy Attorney General Chris Rath, who will present the 3 proposed settlement agreements for the board to consider today. Deputy Rath, when you are ready.
Thank you, Executive Director Klimas. Chair, members of the board, good morning. L. Christopher Rath, Senior Deputy Attorney representing the CCB. We have 3 settlement agreements up for approval at this meeting under agenda item 4. As usual, I'll provide you with a brief summary and the Attorney General's recommendation for approval of each. You may then ask me any questions you wish, and counsel for each of the respondents will also be present to respond to any questions you may have, and then you may decide on the action to be taken for each. Of note, Green Thumb is the parent company for the 3 licensees who have these settlement agreements up for approval today. You will be hearing that request for transfer of interest after we're done with these settlement agreements as agenda item 5. With the chair's permission, I will now start with item 4A.
Please.
Thank you, Chair. The first settlement agreement is for the case of CCB versus Integral Production LLC, which is CCB case number 2020-3. The complaint in this case was filed and served on August 31, 2021. Respondent undertook settlement negotiations with the Attorney General's office after they retained counsel and prior to filing an answer to the complaint. Prior to filing an answer, the parties came to an agreement to resolve the matter that was mutually agreeable to respondent, the CCB staff, and the Attorney General's office. The parties agreed to a stay of the disciplinary process while the CCB considered approval of the settlement agreement before you. The events at issue in the complaint occurred at a production facility in Las Vegas in February 2021. The allegations in the complaint include a failure to fully maintain a proper surveillance system, failure to properly maintain hand washing facilities, failure to maintain minimum hot water temperatures for a sink, and failure to maintain interior surfaces that are smooth and easy to clean. As set forth in the proposed settlement agreement to resolve this matter, respondent admitted to 1 Category 2 violation for failure to maintain a required surveillance system and 1 Category 4 violation for failing to properly maintain hand washing facilities. Respondent also agreed to pay civil penalties in the total amount of $42,500 within 30 days of CCB approval of the settlement agreement. Respondent also provided a plan of correction, which is summarized in paragraph 19 of the settlement agreement, and the CCB staff has approved this plan. The plan of correction includes the following. Number 1, Integral Production has confirmed that a security camera was installed in the room that did not have one. We have further confirmed this fact because they sent in a picture of the room with the new security camera installed. The sink at issue was fully stocked, and stocking the sink was added to the facility's regular checklist. Number 3, the hot water heater was adjusted to ensure it reached the required temperature. And number 4, the interior window surface, which was the one at issue, was changed to one that was smooth and could be easily cleaned. Based on the foregoing, the Attorney General recommends and requests the CCB approve this settlement agreement. I'm available for any questions, as is counsel for the respondent, Mr. Derek Connor.
If we have a licensee and counsel, then please approach.
Good morning, Chairman Douglas, Director Klimas, members of the board and staff. Derek Connor on behalf of Integral Production LLC. I also have representative from the company and my wife and law partner, Amanda Connor.
Good morning, Chairman, members of the board. Anthony Giugiardis here as Chief Financial Officer on behalf of Green Thumb Industries. As Mr. Rath stated, the company has implemented corrective actions, and we kindly request the board approve this settlement agreement.
We have a copy of this. It's and signed off by the parties. The representation that Mr. Rath provided to us, was that a fair representation of what had transpired in terms of the agreement?
Yes, that is a fair representation. And as Mr. Ross stated, the company did take corrective actions to address the deficiencies.
Thank you. Board members, you have any questions you wish to ask? Seeing none, then if we can have, unless someone disagrees, a motion for acceptance of the stipulation in order for settlement of the disciplinary action.
Member Dret, I move to approve the stipulated agreements between Green Thumb Industries and the CCB under agenda item 6. Wait, I'm sorry. Under agenda item 4A. And I'm
And
sorry,
actually-
Integral Productions.
Thank you.
All right, with that, we have a motion now on the floor for acceptance. Do we have a second?
Mr. Chair, I would second the motion.
A motion and a second. Any additional discussion? Hearing none, all in favor of the stipulation in order for settlement of the disciplinary action in this particular case, please say aye.
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 Aye. Any dissents? Any abstentions? Hearing none, motion carries. This matter is accepted and passed. Thank you very much for your cooperation in this matter.
Thank you very much, and thank you very much to Mr. Rath. He was a pleasure to work with as always. Thank you.
Thank you, Mr.
We move to item number 2 in this matter. It's actually item number B as to Essence Tropicana.
Thank you, Chair. Item number 4B is the case of CCB versus Essence Tropicana LLC. CCB case number 2021-50. This case does not involve a complaint, as the parties reached an agreement to resolve the regulatory violations the licensee had self-reported to the CCB. Respondent agreed to waive the filing and service of a formal complaint, as noted in the settlement agreement. This matter involves sales to an underage individual. In late April 2021, Essence Tropicana reported to CCB that a person under 21 years of age had attempted to purchase cannabis at its dispensary on April 15, 2021. The person's ID did not properly scan, so the licensee on its own undertook a further investigation of this issue. On the licensee's further investigation, they found that the same underage individual successfully purchased cannabis at their dispensary on 3 earlier occasions during March and April 2021. The individual was within a couple months of her 21st birthday, but was nonetheless underage. Respondent then voluntarily self-reported these violations to the CCB, and CCB staff reviewed and confirmed these facts. Respondent's self-report also explained the corrective action that Essence Tropicana undertook to ensure that the problem did not occur again in the future. The CCB staff then involved the Attorney General's office to negotiate with the respondent through its counsel to see whether these violations could be resolved with a settlement agreement without the need to file a complaint. We were able to reach a mutually acceptable agreement subject to CCB approval as set forth in the settlement agreement before you. As indicated in the settlement agreement, again, respondent waived its rights to the filing and service of a disciplinary complaint and admitted to the imposition of one Category 2 violation for failing to verify the age of or selling cannabis to a person under the age of 21. Respondent agreed to pay $115,000 as a civil penalty within 30 days. Paragraph 19 of the settlement agreement summarizes respondent's plan of correction, which was also set forth in their self-report. CCB staff has approved this, and it included the termination of the employees making the unauthorized sales, as well as updates to the licensee's IT system to prevent underage sales. Respondent also undertook additional staff training on this particular issue. CCB staff agrees that this admitted violation, the civil penalty, and the corrective action taken appropriately addresses their areas of concern, and that the licensee has also been fully advised about and fully understands the gravity of these issues. Based on this, the Attorney General recommends and requests the CCB approve this settlement agreement. I'm available for any questions on this, as is counsel for the respondent, Amanda Connor.
Good morning, Chairman, members of the board, staff. As Mr. Rath summarized, this was a self-reported incident by my client. They noted a potential violation, investigated it themselves, reported it to the CCB, and took several corrective actions to prevent this from moving forward. We worked with the Deputy Attorney General's office and reached a settlement agreement that we would ask the board to approve.
Questions by board members?
Mr. Chairman, this is Member Nylander. I have a comment and a question, if I might. First, the comment is that I wanted to just express my appreciation that the licensee self-reported this matter. I think it's important as we go further in maturing this industry that these matters, that the licensees are aware that they can self-report, and that then we can avoid going to a complaint. I did have a question on paragraph 19, which is the correction plan that's been submitted. So it sounds like there's been a fence put up within the computer system that now requires the ID to be entered. Otherwise, the computer system will bounce the transaction. I want to make sure I'm understanding that.
My understanding of the safeguard that was put in the system is that there must be a date of birth input through the ID being scanned to complete the transaction. So it is essentially an electronic fence that would prevent the transactions from moving forward.
Okay, and then my follow-up is just how is it working at this time? Have you had any issues with it, or does it seem to be solving the problem?
In my discussions with the director of retail operations that oversees the stores that they operate, my understanding is that it is working well, and that they implemented staff training on how to utilize the process, and that it is working to ensure that the IDs are verified and the date of birth is verified.
Great. Okay. Thank you for that.
Other board members? My question is directed at our staff. This was an action undertaken by an employee. Are we pursuing any action as to that employee? I know that he was terminated, but clearly that's a violation of his part.
Thank you, Chair. My understanding is staff is looking into that and considering it at this time.
If you would please report back to the board as to the status of that.
We will.
As has been stated, it is appreciated that you are using your due diligence to self-report. Thank you for that. Do we have a motion for approval as to this matter?
Mr. Chairman, with respect to agenda item number 4B involving Essence Tropicana, I would move that the board approve the proposed settlement agreement.
We have a motion for acceptance of settlement agreement. Do we have a second?
This is Member Young. I'll second that.
We have a motion. We have a second. Do we have any additional discussion for the record? Hearing none. All in favor, please say aye.
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 Aye. Any nays? Any abstentions? Motion carries. Thank you.
Thank you. And thank you to Mr. Rath for working with us on this.
Thank you.
Which moves us to our C item, consideration for approval of settlement as to Essence Henderson. C.
Thank you, Chair. This is for CCB versus Essence Henderson LLC, CCB case number 2021-51. Again, this case does not involve a complaint, as the parties reached an agreement to resolve the regulatory violations that this licensee self-reported to CCB. Respondent had agreed to waive the filing and service of a formal complaint, as noted in the settlement agreement. This matter involves medical cannabis sales to an adult use customer. In July 2021, Essence Henderson reported that it had found out that its employees had failed to comply with the licensee's policies and procedures and had inadvertently sold medical cannabis products to an adult use customer via the curbside service on 2 occasions during July 2021. Respondent voluntarily self-reported these violations to CCB, and CCB staff then confirmed these facts. Respondent's self-report also explained the corrective measures that Essence Henderson undertook to ensure the problem did not occur again. CCB staff, as with the last case, then involved the Attorney General's office to negotiate with respondent through its counsel to see whether the violations could be resolved. Settlement agreement following a complaint. We were able to reach a mutually acceptable agreement subject to CCB approval. As indicated in the settlement agreement, respondent waived its rights to the filing and service of a disciplinary complaint and admitted to the imposition of one Category 3 violation for exceeding the maximum serving requirements for cannabis products. Respondent agreed to pay a $25,000 civil penalty within 30 days. Paragraph 19 of the settlement agreement again summarizes respondent's plan of correction, which was also set forth in their self-report. CCB staff has approved this plan. It includes updates to the respondent's point of sale software system, which would in effect not allow products to be sold to medical cannabis products to be sold to a customer unless their required medical documents are uploaded into the system first. Respondent also undertook employee training on this software update. CCB staff agrees that the submitted violation and the civil penalty and the corrective action taken appropriately addresses their areas of concern. And based on this, the Attorney General recommends and requests that the CCB approve the settlement agreement. I'm available for questions, as is Amanda Connor, who is counsel for respondent.
Good morning, Chairman, members of the board, and staff. As indicated by Mr. Rath, this was a self-report by my client of a potential violation that they learned of, investigated, reported, and took several corrective actions to address. We kindly request that the board approve this settlement agreement.
Questions by board members?
Mr. Chairman, this is Member Nylander. Similar to the last item in paragraph 19, we do have a description of the software upgrades that were made. And I just wanted to get some confirmation from the licensee that fixed the issue that caused this sale to be in violation.
Member Nylander, again, am talking to the Director of Retail's operations with the company. It is my understanding that this implementation in the software system acts like another electronic fence, make sure that the medical information is implemented, and with staff training that this has been working well.
Great, thank you.
Other comments? Again, for the record, Chair Douglas, it's great that you're now implementing this electronic system and that you're noting in both cases, you're going to make sure that you have adequate education for your employees. So if we have some kind of electronic breakdown, things still fall within the ambit of the rules and regulations that have been set forth. Again, for our staff, just looking into the individual who made the sale, they are obligated, irrespective of the licensee, of the responsibility to act within the rules. When they get their card, they're told certain things are allowed and certain things are not. And whether it's something that needs to go to action or whether it's just a review from our standpoint, employees with cards working in the industry that put the licensee at risk as well are held accountable for their actions as well as licensee. So again, we appreciate self-reporting in this case and your corrective measures. Having said that, unless another board member wishes to state something for the record, do we have a motion for acceptance of the stipulation for settlement and disciplinary action?
Mr. Chairman, with respect to agenda item 4C involving Essence, I would move that the board approve the proposed settlement agreement as stated on the agenda.
We have a motion. Do we have a second?
This is Member Young. I'll second that.
We have a motion. We have a second. We have any additional discussion? With that, all in favor, please say aye.
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 Aye. Any nays? Any abstention? Motion carries. Thank you very much. And to the licensee, thank you for your diligence.
Thank you.
Thank you.
That moves us to item number 5, request for transfers of interest, Green Thumb Industries.
Thank you, Chair. So we'll move on to agenda item number 5 here. Chief Staley is significantly under the weather today, and so we are lucky to have Rachel Branner from the Investigations Division here in person to present on the TOI and the Management Services Agreement. I did convince Chief Staley to be online in the shadows in case there are any additional questions, but I know that Rachel is, or Ms. Branner is more than capable. So Ms. Branner, when you're ready, go ahead and present agenda item number 5.
Thank you, Director Klimas. Chair Douglas, Member Nylander, Member Durrett, and Member Young. For the record, I am Rachel Branner, Compliance Audit Investigator 3, the CC. I'm here to present agenda item number 5, which consists of 1 transfer of interest or TOI application. Item A is a TOI application for Green Thumb Industries, Inc. or Green Thumb. TOI number 19072 is a request to consolidate the remaining 2% ownership in one of Green Thumb Productions operations, CCLV Production, and 100% of CCLV Production to another of Green Thumb's intermediary companies, CCLV Manufacturing. CCLV Manufacturing was inadvertently omitted by taxation as the direct owner of CCLV Production in a previous TOI approval issued in April 2019. TOIs 19081 and 19084 through 19089 are board member and officer changes that were assigned TOI numbers in error and are included in this agenda item to remove them from the pending TOI list. Staff identified no areas of concern with this application. Staff also suggests that if this item is approved, Green Thumb's requested 5.112 and 5.125 waivers expire on such agenda item as Green Thumb's next TOI application is heard. I am available for any questions, and my understanding is that Amanda Connor, along with members of Green Thumb, are present to provide a brief presentation to the board and to address any questions you may have. With that, Chair Douglas, I will turn this item back to you.
Thank you.
Good morning, Chairman, members of the board, and staff. As Ms. Branner described, this is a request for a transfer of interest for Green Thumb Industries to acquire a remaining 2% in CCLV Production. The GTI, or Green Thumb Industries, acquired Integral Associates, and it was approved in 2019. And in that approval, there was a 2% interest in CCLV Production that was not acquired, and this is to acquire that last 2%. Also, at the time in April 2019, when the Department of Taxation approved the large acquisition, inadvertently, the approval left out CCLV Manufacturing being the 100% sole member of or 98% member of CCLV Production. So this is a clarification as well. We have appreciated working with Jane Maurer throughout this entire investigative process in which she investigated Green Thumb Industries and its various licenses held throughout the state. We compliment the board and its staff for developing a rigorous process that we have seen come to fruition and are pleased that there were no areas of concern. We kindly ask the board to approve this transfer of interest.
Thank you. Questions, board?
So-
Chair Douglas. Go ahead, Dennis.
Sorry, Mr. Chairman. So this really is just a cleanup, Ms. Connor, correct? There were a number of entries, looks like clerical issues back in 2019 where there was an application filed, but it didn't get recognized.
So correct in that this is a cleanup, except for it is also an acquisition of a remaining 2% in one production license that was not acquired with the initial acquisition in 2019. But for the most part, this is a cleanup of a clerical error in the approval that was issued by Department of Tax.
Okay, thank you. I didn't have any other questions.
Yeah, just noting that Green Thumb has been with us since 2016, originally coming into our market. They are operating in 12 states, where they own and operate 13 cultivations, production facilities, and 97 dispensaries, and another 10 states where they are wholly owned and licensed cannabis. We had no areas of concern with this change, and thank you for getting that cleaned up. With that, do we have a motion for approval?
Mr. Chairman, I would move for approval of agenda item 5A, the transfer of interest for Green Thumb Industries, and that approval would be conditioned that the waivers of NCCR 5.110 pursuant to NCCR 5.112 and NCCR 5.125 are conditioned to expire on such agenda date as Green Thumb Industries' next TOI application is heard.
We have a motion on the floor. Do we have a second as to that motion?
This is Member Young. I will second that.
Thank you, Mr. Young, Dr. Young. We have a motion. We have a second. Any additional discussion? All in favor of approval of the transfer of interest, please say aye.
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 Aye. Any nays? Any abstentions? Hearing none, motion carries. Thank you very much.
Thank you. And again, thank you to Ms. Mauer and Mr. Staley on working with us on this.
Next on our agenda, item number 6, consideration for approval of management service agreements. We have 3 items.
Thank you, Chair, and we will stick with Ms. Rachel Branner to present the 3 management service agreements before the board today. Ms. Branner, when you're ready.
Thank you. Chair Douglas, members of the board, once again, for the record, I am Rachel Branner, Compliance Audit Investigator 3 CCB. I am here to present agenda item number 6, which consists of 3 management service agreements, or MSAs. Item A is a June 8, 2021 MSA between Green Therapeutics and CPCM Holdings. The MSA provides for CPCM Holdings to manage and operate all aspects of day-to-day business of Green Therapeutics production operations in North Las Vegas, Nevada. CPCM Holdings will receive a management fee of the net monthly profit after capital expenditures, less $10,667 per month. The MSA has been put in place pending the completion of staff's review of a transfer of interest application in which CPCM Holdings has applied to acquire Green Therapeutics North Las Vegas production license. CCB staff have reviewed the agreement and found it appropriate. CCB staff recommends that the board consider approval of the relationship between CPCM Holdings and Green Therapeutics rather than approval of the agreements themselves. I'm available for any questions, and my understanding is Amanda Connor and other executives are present to make a brief presentation to the board and address any questions you may have as well. With that, Chair Douglas, I will turn this back to you.
Thank you. Lauren?
Good morning, Chairman, members of the board, staff. As Ms. Branner indicated, this is a request for an approval of the relationship between a management agreement for CPCM Holdings, which the board may commonly know as Thrive, to manage Green Therapeutics North Las Vegas production license. There is a pending transfer of interest, so the intent is that this management agreement will stay in effect until the transfer of interest is approved. If there are any questions, I have Mitchell Britton here, one of the owners of CPCM Holdings with me, and we are happy to address those.
Thank you. Board members, any questions or concerns at this point? Mr. Nylander is shaking his head no.
Trying not to
Yes,
interrupt,
sir.
Mr. Chairman.
With that, then, if there's no questions, can we have a motion for approval of management services agreement? And we note for the record, our staff had no concerns.
Mr. Chairman, I would move for approval of agenda item 6A. And that is a approval of the of this relationship and not the agreement.
Duly noted. Do we have a second?
This is Member Young. I'll second that.
A motion, a second. Any additional discussion? None. All in favor, please say aye.
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 Aye. Any nays? Any abstentions? Motion carries. Thank you very much.
Thank you, and thank you, Ms. Brenner.
That takes us to item B, Zenway Corp. and Platinum Management Company.
Thank you, Chair. Item B is a June 9th, 2021 MSA between Zenway Corp. and Platinum Management Co., or Platinum. The MSA provides for Platinum to manage and operate all aspects of day-to-day business of Zenway Corp.'s cultivation operations in North Las Vegas, Nevada. Platinum will receive a management fee directly dependent on the amount of aggregate product in excess of 100 pounds at the rate of 90 cents per gram or $508 per pound. The MSA has a one-year term which automatically renews annually unless the agreement is terminated. CCB staff have reviewed the agreement and found it appropriate. CCV staff recommends that the board consider approval of the relationship between Zenway Corp. And Platinum Management Co. rather than the approval of the agreements themselves. I am available for any questions, and my understanding is that Amanda Connor and company representatives are present to make a brief presentation to the board and to address any questions you may have as well. With that, Chair Douglas, I will turn this item back to you.
Good morning, Chairman, members of the board, and staff. I'm here today with Mr. Ackle, a representative of the proposed management company. We kindly request approval of this management agreement. The board may remember that Zenway was in front of you a few months ago for approval of a settlement agreement. And one of the corrective actions was that they were proposing to bring in a management company to help them with operations and to understand the regulations and requirements in Nevada cannabis. This is that management agreement that was one of their corrective actions. We kindly request the board approve the management relationship and are here to address any questions.
Again, we have no concerns raised by staff as to this, but with that, having said that, any questions or concerns that our board members wish to put forward?
Mr. Chairman, this is Member Nylander. I have a quick question for the executive director. And this is not applicable just to this item, but I just wanted to make sure, are we baking into our audit programs a review of these management agreements as we go with regular audits on the compliance side?
So Member Nylander, Tyler Cannabis for the record. So are you asking during our annual and follow-up audits, do we take into account the management agreement and the individuals that were brought in to manage the operations as part of the audit?
Yes, because with these agreements, they're all a little bit different and some of them expire, but they're renewed. And I just want to make sure that we're also staying on top of that. So some of them are for long term. I've seen one recently, 5 years, one that was 10. This one in particular is 1 year. I just want to make sure we're accounting for that in our review on a go-forward basis. Yeah.
Sure, and thank you for that. And so in a situation like this, it's a shorter term, it's a year to what I assume would be get the licensee back on track. Also assuming that once it ends, it's the licensee's responsibility. And so Member Nylander, if I hear you correctly, ensuring that that's baked into our audit process, understanding when the the management service or the management services agreement ends, and when the licensee then takes over full responsibility, making sure that we bake that into our audit process as well, following any kind of termination of a management services agreement. Would that be correct?
Yes, yeah, that satisfies my question. And again, not for Ms. Connor, this is not necessarily specific to this item. I'm all in favor of this management agreement because it cures a big problem we had with the previous violations. So thank you, Mr. Chairman. That's all I had.
Other board members?
Chairman, I have a follow-up question to Director Klimas. When these agreements come up again for renewal, do they have to come back before the board, or are they just automatically renewed?
Dr. Young, it's a great question, and I believe that we had a discussion about that a number of months ago at a past board meeting. I'd have to go back to the minutes. I know there was a request by the board. I think we were looking at some very long-term agreements, and they may have been shortened after that discussion. But I do not recall where we ended up as far as when those automatic renewals would take place, if they would come back in front of the board. I believe the request from the board was to have the parties come back before renewal took place. But Member Young, I'd have to go back and confirm that.
Great, thank you.
If we have nothing else at this point, if we can have a motion, and I note that there were no areas of concern as to the relationship, if we can have a motion.
This is Member Young. Go ahead. This is Member Young. I'll move that we approve the relationship in agenda item 6B, Zenway Corp. And Platinum Management.
Thank you, Dr. Young. Do we have a second?
Mr. Chair, I would second the motion.
We have a second from Mr. Islander. Moved and seconded. Any additional discussion? All in favor of approval, please say aye.
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 Aye, motion carries. Any abstentions or denials? Hearing none, motion carries. Thank you.
Thank you, and thank you, Ms. Brennan.
This is to C, Luff Enterprises. And the
Thank you, Chair.
Palmyra, Nevada LLC.
Thank you, Chair. Item C is the June 9, 2021 MSA between Luff Enterprises NV Inc. or Luff and the Farmari Nevada or Farmari. The MSA provides for Farmari to provide business, organizational, strategic, management, and advisory services to Luff for both their cultivation and production operations in Las Vegas, Nevada. Farmari will receive a management fee of 50% of monthly revenue, less expenses incurred. The MSA has been put in place pending the completion of an asset purchase agreement whereby a Farmari-related entity will purchase the property where the cultivation and production facility is located. Staff have reviewed the agreement and found it appropriate. Staff recommends that the board consider approval of the relationship between Luff Enterprises NV and the Farmari Nevada rather than approval of the agreements themselves. I am available for any questions, and my understanding is that Alicia Ashcraft and other executives are present to make a brief presentation to the board and address any questions you may have as well. With that, Chair Douglas, I will turn this item back to you.
Good morning.
Good morning, Chair Douglas, Director Klimas, and members of the board. Alicia Ashcraft of the law firm of Armstrong Teasdale. I'm here on behalf of the management services company, the Farmari. With me here at the podium is Philip Silvestri of the law firm of Greenspoon Martyr on behalf of Luff Enterprises. And then by way of Zoom, we also have available the president of Luff Enterprises, Philip Campbell, and the manager of the Farmari, Jeffrey Field. And we're happy to answer any questions. As indicated, this is an interim management agreement. It's part of an acquisition of the building and the licenses. We are grateful to Ms. Branner for her work on this item. Again, happy to answer any questions and respectfully request approval of the relationship under the management agreement.
Yeah, you noted that this was presumptive acquisition. Staff had no basic concerns. Having said that, members of our board, do you have any concerns or questions you wish to ask? It appears there's no questions. And if we can have a motion for approval.
I guess this one's not getting approved. I move to approve. Agenda
Member
item
Durrett.
6C.
Thank you, member. Do we have a second? Has the motion?
This is Member Young. I'll second that.
It's been moved and seconded. Any additional discussion? Hearing none, all in favor, please say aye.
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 Aye. Any nays? Any abstentions? Motion carries. Thank you very much and good luck.
Thank you.
Thank you.
Before we leave this-
Mr. Chairman, before you leave item 5, or I'm sorry, item 6, could I just make a comment for Tyler?
Yes, you can, because I also had a comment, so go ahead.
Okay. I'm just sort of trying to recollect that discussion we had. This was some time ago, but I'm wondering if we ought to consider putting conditions on these agreements or these requests for approval of management services agreement, where there's a requirement that the licensee report to the board if there's a material amendment to the agreement, or if the agreement has been automatically renewed, and to state that, the terms, because I don't think if there's any changes, I don't know that we would have to see the people again, but as long as there was some sort of reporting mechanism, so we know the status of the agreement. So it's just something for thought. I don't want to take up a bunch of the board's time, but it's just recollecting kind of at least the basics of the discussion we had previously. So thank you, Mr. Chairman. I'm sorry to interrupt.
My overreaching comments were related to all three that came before us today. There was no major area of concern except concern as to management service agreements themselves. Two of them were for potential acquisition, so it kind of explained the percentages why things were going forward in that nature. But based on duration, based on the question, besides what Member Young and Mr. Nylander had raised as to their concerns areas, we need an overview of what we're doing with these management service agreements, how we as a treating them, and whether or not we're taking deep dives into the management of these service agreements. These outside groups that are coming in, and in essence, they have a stake in this venture. Either it's almost like a profit sharing, or depending on how they're being paid or reimbursed for their services on a monthly basis. We need to take a look at this, because over the last few months, we've had a number of these coming in where we have corporations, or use the term absentee owners, who are having their businesses, which they are responsible for, run by outside entities. We need to know who they are, more than just the people who are here working that particular operation, if we are to have some semblance with our responsibility to know who is running these types of privileged businesses. So if we can get a report back in a few months from our director as to kind of where we're at, and any maybe recommendations based on some of the questions, so we can go forward with a comprehensive policy in the future.
Chair, certainly we can do that. And to Member Nylander's comment, I do believe those are, that is something that we can put in the approval letter as part of the requirements for the agreement as well. So we'll make that change and fix as well.
Chair,
That
may
moves
I
us-
add to that?
Yeah, yes, go ahead.
Maybe we've already done this, or maybe director's already done this, but maybe we should also ask management agreements that were in existence before the CCB was created to be submitted, just to have them on file. That's just for discussion.
Certainly, Tyler Climate, for the record, that's something that we can explore. And there may be some other mechanisms as far as other approvals that we can use to get any updates to management service agreements that may have been initiated prior to this board taking over oversight. So thank you for that.
If we have nothing else as to looking at this area, then we'll move over to item number 7, consideration of proposed amendments and or additions to Nevada Cannabis Compliance Regulations. Regulation 11, Cannabis Independent Testing Laboratories, specifically NCCR 11.015, requirements for testing facilities to handle, test, or analyze cannabis. This is on for possible action.
Thank you, Chair. So agenda item number 7, NCCR 11.015. This was a proposed change to the regulation that was in front of the board at its July board meeting. As the chair just mentioned, this proposed change deals with preventing testing laboratories within their business practices from providing any kind of discounts or waiving fees for undesirable test results. Again, staff working to promote impartiality in the testing industry. There was a public comment received by a representative of a lab at that July meeting questioning the board's ability to reach into business practices. Chair, you had asked that the regulation just be held back and have our council take an extra look at that. Council did a great job in analyzing the issue, provided that analysis to the board members. Council feels very comfortable moving forward with this proposed regulation and where we're at. And so that regulation that was informally workshopped and formally workshopped and has already been in front of the board at one time is now back in front of the board for consideration. So with that, Chair, I'll turn it back to you. We have Ms. Balducci here. We can answer any questions that you have on the regulation or on the analysis. So Chair, back to you.
Thank you. We note that this matter is on for action today. We note that we have a concern that was raised that's properly on the record. We also received some information in our public comment area as to some concern with that. But having vetted this, I think it's appropriate to go forward today to see if we rise or fall, so to speak, as to the proposed regulation and the amendment. Any board member wish to weigh in on this at this time in terms of any concerns or their position?
Chairman, I do have a comment on the regulation. Is now a good time to express that?
If you could repeat yourself.
Oh, I have a comment on the regulation. Is now good, or should we hear the presentation?
Yes.
Okay. Okay. I think that I agree with the public comment that was submitted. No, I'm sorry. I don't know. I believe that the comment that the CCB shouldn't regulate specific business practices has some merit, but I do believe that we do have the authority to go forward on this. That was kind of the question. The public comment was saying that the CCB doesn't have authority, and I completely agree with the DAG's assessment that we do have authority. I am a little weary of implementing specific regulations on business practices, but in the absence of a better proposal, I do support it. And so I would encourage those that disagree with it to submit a petition with a proposal for the board to consider and to determine whether that's a better way to handle it. But for now, there's no better proposal. And so I will go ahead and support the current proposed regulation. Sorry, that took me a little while to articulate it.
No, that's fine. You made the points that you felt were necessary. Other board members wish to weigh in?
Mr. Chairman, I'm in support of adopting the regulation. I carefully considered the arguments that have been made. I think our attorney generals have made a very solid case that we're certainly within the bounds of our authority to do that. And this is necessary in my view in order to maintain impartiality within the independent testing space. So I intend to support it today.
Thank you. Dr. Young, do you wish to make any comment, or are you fine with silence at this point?
I support the change for a number of reasons. I think it keeps the integrity of the testing system. I think that's an essential part of protecting the public.
Thank you. And for the record, Chair Douglas, I likewise will support it. I think this was a interesting exercise in terms of looking at what our authority is, making sure we're in compliance with it. But more importantly, the issue at hand is the integrity of the testing procedure. And as Member Durrett outlined, if there's a better way to do it, and we're kind of at an impasse as we learn and we grow, please come back to the table with something of that nature for consideration. That is my comment. With that, we have a motion for approval of proposed changes to NCC or Regulation 11, more specifically 11.015.
Mr. Chairman, with respect to agenda item 7A1, the proposed amendments to NCCR 11.015, I would move that the board approve the amendments to the regulations.
Thank you. Do we have a second?
This is Member Young. I'll second that.
Thank you, Dr. Young. With that, any additional discussion? Hearing none, all in favor, say aye.
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 Aye. Any abstentions? Anyone wishing to vote nay? Motion carries. Motion's been approved, subject to the necessary compliance with statute.
All right, Chair, we'll move on to agenda item number 8. This is the consideration approval to extend the February 5th, 2022 final inspection deadline. We've had a few of these the last couple board meetings, so we'll move forward with 4 here today. Chief Steve Gilbert is in Carson City, and he will present on the 4 in front of the board today. So Chief Gilbert, when you're ready, go ahead.
Thank you, Director Klimas. Good morning, Chair, members of the board. Steve Gilbert, Chief of Administration for the record. I am here today to present agenda item number 8, which consists of petitions submitted by Cheyenne Medical LLC, Essence Henderson LLC, Deep Roots Harvest Inc., and Qualcan LLC to extend the February 5th, 2022 deadline to receive a final inspection by the CCB. The 4 licenses listed submitted petitions to the CCB to extend their deadline to receive their final inspection. The petitions in front of you today are related to county moratoriums on cannabis establishments. I'll be going through each licensee's requests separately. Agenda item 8A is for Cheyenne Medical LLC. Lone Mountain Partners LLC was issued conditional adult use retail store license RD 598 on December 5th, 2018 within the Douglas County jurisdiction. On October 12th, 2020, the Cannabis Compliance Board issued a notice to Lone Mountain Partners that its retail store facility must be inspected and approved for final licensure by the CCB and complete appropriate local government requirements no later than February 5th, 2022, or the license will expire. At the October 20th, 2020 CCB board meeting, transfer of interest number 21009 was approved, transferring Lone Mountain Partners RD 598 license to Cheyenne Medical RD 598 LLC, who we'll refer to as Cheyenne 598. On November 3rd, 2021, Cheyenne 598, through its legal counsel, submitted a letter to the CCB requesting an extension of the February 5th, 2022 deadline. Specifically, Cheyenne 598 requested an extension for 14 months after Douglas County lifts its moratorium. In its request, management reported that the Douglas County jurisdiction currently has a moratorium on all cannabis establishments. Cheyenne 598 did not provide any documentation or copies of correspondence showing its efforts to work with Douglas County jurisdiction to change the ordinance that is in place. CCB staff confirmed with Douglas County that there is a prohibition on cannabis establishments in the county per ordinance number 2014-1418, section 3, 20.660.170. Staff has communicated to Cheyenne 598 that there are no areas of concern and has asked the licensee to be prepared to discuss its progress at the board meeting. Cheyenne 598 obtained conditional license RD 598 via the July 28, 2020 licensure settlement agreement. Pursuant to paragraph 18 of that settlement agreement, the CCB agrees to extend the deadline for any settling party to obtain final inspection and approval from CCB on any and all conditional license in such jurisdiction for a period of 14 months after the date any moratorium is lifted in such jurisdiction. Based on the language in the settlement agreement, CCB staff and legal team feel the extension for a period of 14 months after the date Douglas County moratorium is lifted is appropriate. I'm available for any questions, and my understanding is that Amanda Connor and Mitchell Britton are present today to give a brief presentation and address any questions you may have as well.
Good morning, Chairman, members of the board, and staff. As Mr. Gilbert indicated, my client is kindly requesting the extension of time as agreed to in the settlement agreement that would be 14 months from the date that Douglas County lifts its moratorium. Today with me, I have Mitchell Britton, one of the owners of Cheyenne Medical RD 598 LLC. As Mr. Gilbert indicated, they acquired this license pursuant to terms of the July 2020 settlement agreement. Mr. Britton did retain individuals to help him work with Douglas County on lifting the moratorium, and himself met with the county commissioners in Douglas County. But as of today's date, there is still a moratorium, and we kindly request that the extension be granted.
Thank you. Do we have anything else? Board members, have we had, I know we had lengthy discussions last month at our meeting based on these and status in various counties, and asked our director to have conversations as to the status and report back to us once he's done that. I note for the record myself, I think it's more appropriate that we extend their extension again a year out, in general, noting that they would have 14 months from any licensure to complete, so that we keep this on calendar coming back and we don't lose track of it. That's my concern with these outstanding licenses. So it just brings them back, but honoring, and we understand they get a year, but if they're granted a license within that year, they'd have 14 months from that point. But we'd want them back in a year just to give us an update as to what's happening in that particular county. Because this is a concern as to our counties, some becoming educated and others are still just refusing to participate. Other comments by board members?
Yeah, Mr. Chairman, this is Member Nylander. Just a comment and a question. So for some of these, like I reside in Douglas County, that's a tough row to hoe. Trying to get that county commission to so I don't see that happening anytime soon. But anyway, that's more of a comment. The question I have, Mr. Chairman, is, and I may be misremembering this, but if we're going to do 12 months, would it be 12 months from February 5th, 2022, or 12 months from today?
It would be from the exploration of February 2022.
Okay, thank you. That's what I thought. I just wanted to make sure I was
That
clear
was-
on that.
Yeah, that was the clarity that we got last meeting in our exchanges. It would go from the ending of this licensing period in 2022, February, 12 months out. And they'd have the 14 months if something happened. If not, we get a report and they could then request a continued extension. Just trying to
Okay.
keep track.
Yeah, no, I understand. I think I messed the motion up last time, so I just wanted to clarify that.
I don't think you messed it up, but we had a good time with the ball in play. Other concerns or just re-edification for the record? Okay. Then if we can have a motion on this, and I guess I would make the motion to extend the basic extension, give them a new 12 months from February 5th, 2022, and that if a license be granted during that period, or the allowance in that county, they'd have 14 months to go forward with their activity, and that the matter would be openly brought back before us in 1 year for consideration. Nothing is happening for status. That would be my motion.
I would second that motion, Mr. Chair.
We have a motion, we have a second. All in favor, please say aye.
Aye.
Aye. Any nays? Any abstentions? Motion carries. Thank you, and we understand.
Thank you, Chairman. If I could clarify, just to make sure we understood your motion, it is that you're asking them to come back and give a status in 12 months, but they are in fact given the 14-month from the time the moratorium's listed.
Yes.
Okay. Thank you.
That moves us to our B item, Essence Henderson LLC.
Thank you, Chair. Agenda item 8B is for Essence Henderson LLC. Essence Henderson LLC was issued a conditional adult use retail store license, RD 347, on December 5th, 2018, within the Sparks jurisdiction. On October 12, 2020, the Cannabis Compliance Board issued a notice to Essence Henderson that its retail store facility must be inspected and approved for final licensure by the CCB and complete appropriate local government requirements no later than February 5th, 2022, or the license will expire. On August 9th, 2021, Essence Henderson, through its legal counsel, submitted a letter to the CCB requesting an extension of the February 5th, 2022 deadline. Specifically, Essence Henderson requested an extension for 14 months after the City of Sparks lists its moratorium, as mentioned in the licensure agreement, litigation settlement agreement dated July 28th, 2020. In its request, management reported that Sparks jurisdiction currently has a moratorium on new adult use cannabis establishments. Both CCB staff and Essence Henderson contacted the City of Sparks staff. Both the city attorney and the community services director confirmed current city code section 20.03.025D does not allow for standalone adult use retail dispensaries. Adult use retail stores are only allowed at existing medical facilities. Staff has communicated to Essence Henderson that there are no areas of concerns and has asked the licensee to be prepared to discuss the progress at the board meeting. It appears Essence Henderson has not been able to perfect its adult use retail store license due to Sparks City Code section 20.03.025B, and approval of the extension request would be appropriate. I'm available for any questions, and my understanding is that Amanda Connor and Anthony Georgios are present today, and Brendan Bloom is present via Zoom to give a brief presentation and address any questions you may have as well.
Good morning, Chairman, members of the board. As Mr. Gilbert indicated, we're here to kindly request a 12-month extension from the February 5th, 2022 deadline for my client's retail store located in Sparks Sparks currently has a moratorium such that you cannot open an adult use retail cannabis store unless it's also combined with a medical marijuana dispensary. My client has retained the service of Will Adler to work with the city of Sparks. Communication, as Mr. Gilbert indicated, from the city of Sparks was sent to CCB staff confirming that there is still a moratorium in place and that the timing of to lift said moratorium would take approximately 6 months, and then they would have to begin the facility. Therefore, we kindly request this 12-month extension.
Having heard that and pointing out the distinction between item A, which we heard where we have a complete moratorium as to all, versus this where we have a specific as to the integration of medical and retail. Board members, questions, concerns? And noting staff had no concerns. For the record, then Chair Douglas, a motion to approve extension for 12 months. From the February 5th, 2022 timeline to, in essence, February 5th, 2023. In this case, and noting that they would have 14 months from any extension is granted during this timeline, and that they're free to come back next year and ask for an additional extension. That would be my motion.
Second the motion, Mr. Chair.
It's been moved in second. Any additional discussions at this time? Hearing none. All in favor, please say aye.
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 Any nays? Any abstentions? Hearing none, this matter carries.
Thank you.
Thank you. We then move to item C, Deep Roots Harvest, Inc.
Thank you, Chair. Agenda item 8C is for Deep Roots Harvest, Inc. Deep Roots Harvest, Inc. has issued a conditional adult use retail store, RD 401, on December 5th, 2018, within the Henderson jurisdiction. On October 12th, 2020, the Cannabis Compliance Board issued a notice to Deep Roots that its adult use retail store facility must be inspected and approved for final licensure by the CCB, and it must complete appropriate local government requirements no later than February 5th, 2022, where the license will expire. On October 14th, 2021, Deep Roots, through its legal counsel, submitted a letter to the CCB requesting an extension of the February 5th, 2022 deadline. Specifically, Deep Roots requested an extension of 18 months to perfect the license. Deep Roots provided documentation to demonstrate their efforts to work with Henderson jurisdiction toward an end result of becoming permanently licensed within Henderson prior to February 5th, 2022, including 2 meetings they had with the City of Henderson representatives. The CCB agent contacted the business operations manager for the City of Henderson on August of 2021, who confirmed Henderson currently has a co-location requirement for adult use and medical cannabis establishments, which is Henderson Code of Ordinance, Chapter 4.118.070B1, which states a retail marijuana store shall only be operated in conjunction with an existing medical marijuana establishment at the same address, and must be licensed by the same license holder as a medical marijuana dispensary license pursuant to Chapter 4.116. Staff has communicated to Deep Roots that there are no areas of concern and has asked the licensee to be prepared to discuss its progress at the board meeting. It appears that Deep Roots has made the best efforts to perfect its adult use retail store license, but has been unable to do so due to the Henderson Code of Ordinance, Chapter 4.118.070B1, and approval of its extension request would be appropriate. I'm available for any questions, and my understanding that Anthony Arger and Keith Capurro are present today to give a brief presentation and address any questions you may have as well. They're here in Carson City.
Thank you.
Thank you, Mr. Gilbert, for that brief presentation. Thank you, members of the board and Chair Douglas. Anthony Arger on behalf of Deep Roots Harvest, Inc. As Mr. Gilbert indicated, Mr. Keith Capurro is here with me today. He's the president and CEO of Deep Roots Harvest, Inc. Just to add a bit more background on the efforts of Deep Roots Harvest to date, starting in March of 2020, we retained Donald Carano to assist in the efforts to work with the city of Henderson to try and come up with a new ordinance. So from March of 2020 to August of 2021, a period of roughly 17 months, we were working very actively with the city of Henderson, and we actually submitted and in working with the city had come to what we thought was a final ordinance that would be in place. At that point, Deep Roots actually purchased for approximately $2.5 million the location where they were going to, and hopefully still will be able to, build out the facility. However, in the agenda item, the ordinance was placed. We received word that it was going to be placed as an agenda item on the September 21st, 2021 meeting for the city of Henderson. Unfortunately, it was pulled just days before. There were some still ongoing issues within the city of Henderson. We have continued to meet with individuals including the mayor, the city attorney, and legal counsel for the city of Henderson to continue working through this issue. We are hopeful that the 18 months will give us time. We're hoping within the next year the ordinance can be changed. And then the additional time that we're requesting is for the build out of the space. There is a building there. However, it's going to take a fair amount of build out of TIs in the space, which is why we're requesting the additional roughly 6 months on top of 12 months.
Questions by any of our board members? No questions. I would make, to be consistent, same motion previously made, that we give a 12-month extension from beginning after the February 5, 2022 timeline into 23, and that should a moratorium be lifted, they have 14 months from the lifting of that moratorium to complete whatever is necessary for the licensure. To be consistent, have it brought back on, and if you're still going forward, feel free to come back and ask for additional. That would be my motion. Do we have a second to that motion?
Second, Mr. Chairman.
We have a motion, we have a second. Is member Durrett still on? Or did we lose her? We still have a quorum.
I'm here.
Okay, just wanted to make sure. We have a motion, we have a second. All in favor, please say aye.
Aye.
Aye. Any nays, any abstentions? Hearing none, the motion carries. Thank you and good luck. This takes us
Thank you, Your
to
Honor.
item.
Thank you, Mr. Gilbert.
This takes us to item D, Qualcan. If I pronounced it right.
Agenda item 8D is for Qualcan LLC. Nevada Organic Remedies LLC was issued conditional adult use retail store license RD222 on December 5th, 2018 within the Carson City jurisdiction. At the August 25th, 2020 CCB board meeting, transfer of interest request number 21007 was reviewed and conditionally approved, transferring Nevada Organic Remedies LLC RD222 license to Qualcan LLC. On October 12th, 2020, the Cannabis Compliance Board issued a notice to Qualcan that its retail store facility must be inspected and approved for final licensure by the CCB and complete the appropriate level government requirements no later than February 5th, 2022, or the license will expire. On November 1st, 2021, Qualcan submitted a letter to the CCB requesting an extension of the February 5th, 2022 deadline. In its request, management reported that the Carson City jurisdiction currently had a moratorium on new adult use cannabis establishments. Qualcan indicated that it has been working with lobbyists to lift the moratorium in Carson City. However, Qualcan has not provided any documentation demonstrating its efforts to work with the jurisdiction to lift the moratorium. Staff has communicated to Qualcan that there are no areas of concern and has asked that the licensee be prepared to discuss its progress at the board meeting. Qualcan obtained conditional license RD222 via the July 28, 2020 licensure settlement agreement. Pursuant to paragraph 18 of that settlement agreement, the CCB agrees to extend the deadline for any settling party to obtain final inspections and approval from CCB on any and all conditional licenses in such jurisdiction for a period of 14 months after the date any moratorium is lifted in such jurisdiction. Based on the language in the settlement agreement, CCB staff and legal team feel the extension period of 14 months after the date Carson City's moratorium is lifted is appropriate. I'm available for any questions, and my understanding is that Michael Cristali is present to give a brief presentation and address any questions you may have as well.
Good morning.
Good morning, members of the board, Chairman Douglas, Director Climas, Michael Cristali appearing on behalf of Qualcan. I would adopt the comments by Mr. Gilbert in regard to the request for the extension. And I would also ask the board to grant the extension consistent with its previous consideration and ruling as it relates to other licensees similarly situated to Qualcan, and I would submit it on that.
We noted in the background that Carson City's similar in terms of the medical and adult dispensary, but they additionally limited to 2 licenses in the jurisdiction.
The chairman, that's correct. It's 2 licenses, so they would have to take it up on an agenda to change that ordinance.
Other board members, any questions of Mr. Casale?
This is Member Durrett. I have a question. I have a vague memory, but I could be wrong. Didn't Carson City issue a letter to applicants before these licenses the licensing round was opened, stating that they would only be licensing a couple and that basically like, don't bother applying here because we're only going to license these ones. We're only going to license a couple. And so if you do it, you do it at your own risk.
Member Durrett, we received the license out of the settlement for the litigation of the Department of Taxation. We were never given such notification by Carson City. We have had direct communication with the Board of Supervisors and staff as it relates to the ordinance. We've been advised that the matter will be agendized and consideration for lifting that moratorium and extending the number of licenses for that jurisdiction will be considered.
Okay, thanks. I couldn't remember if this is one that was involved in the litigation or not. Thank you.
Thank you.
Any other board member wish to weigh in? If not, consistency with the others, and hopefully sounds like there may be some wiggle room now in Carson City as to this item, extending 12 months from the 2022 existing deadline, and additionally noting that they would have 14 months if they change their ordinance during this period of time. And we note that this is also pursuant to the stipulations of tax legislation. But a motion consistent with the other motions for the 1-year extension and 14 months to comply. Anything is lifted.
Second that motion, Mr. Chairman.
It's been moved and seconded. Any additional discussions? All in favor of the motion, please say aye.
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 Aye. Any nays? Any abstentions? Hearing none, motion carries. Thank you.
Thank you. Thank you, Chairman. Thank you, members of the board.
That moves us to item number 9, which is discussion, but our director will update us on approvals, notice of final licensures.
Thank you, Chair. So this item stays with Chief Gilbert. Chief Gilbert, when you're ready, provide these for discussion only to the board.
Thank you. Agenda item 9A is an informational item presented as a notice to the board of establishments that have been issued their final license since the last board meeting. We have 2 licenses to note today. Number 1 is for High Sierra Holistics LLC, RD 665. TRNV 098 LLC applied for an adult use cannabis retail store license during the September 2018 application period held by the Nevada Department of Taxation. On December 5th, 2018, TRNV 098 LLC was issued a conditional license RD 665 for an adult use retail store facility in Lyon County jurisdiction. A transfer of interest request number 21008 submitted by TRNV 098 LLC for RD 665 was heard by the board at the September 22nd, 2020 CCB board meeting and approved, transferring the license to High Sierra Holistics. The TOI approval letter was issued on September 30th, 2020. On October 12th, 2021, CCB staff conducted a pre-opening inspection audit of the facility located at 10115 US Highway 50, Mound House, Nevada. The inspection and audit results revealed that the facility was in compliance with NCCR and Title 56 of NRS. A statement of no deficiencies was issued on October 13th, 2021, demonstrating High Sierra Holistics LLC has met the regulatory operational requirements. The CCB agent contacted Lyon County and no issues regarding High Sierra Holistics were disclosed at that time. As a result, the CCB approved and issued a final license to High Sierra Holistics RD 665 on October 19th, 2021 for an adult use retail store in Lyon County. Number 2 is for Lone Mountain Partners LLC, RD 590. Lone Mountain Partners applied for an adult use retail store license during the September 2018 application period held by the Nevada Department of Taxation. On December 5th, 2018, Lone Mountain Partners was issued a conditional license RD 590 for an adult use retail store license in Spring Valley, Nevada, in the unincorporated Clark County jurisdiction. On September 29th, 2021, CCB staff conducted a pre-opening inspection and audit of the facility located at 5940 West Flamingo Road, Spring Valley, Nevada. The inspection and audit results revealed that the facility was in compliance with NCCR and Title 56 of NRS. A statement of no deficiencies was issued on October 6, 2021 by CCB inspection and audit staff indicating Lone Mountain Partners LLC met the regulatory operational requirements. The CCB agent contacted Clark County and no issues regarding Lone Mountain Partners LLC were disclosed at that time. As a result, the CCB approved and issued a final license to Lone Mountain Partners RD 590 on October 20th, 2021 for an adult use retail store license in unincorporated Clark County. With that, Chair, members of the board, I'm happy to answer any questions.
This item is on for information. Nothing more needs to be done by the board, but if the board has any questions as to either one of the licensees, please ask the questions. If not, we can move our agenda. Hearing no questions, we will move to, and I'll roll them together, item number 10 and item number 11. Item number 10 is the Cannabis Advisory Commission updates and draft of kind of the report. And item 11 is briefing to the board from our executive director. So you'll just kind of roll them together.
Yeah. Take that as a sign, Chair. Thank you. All right, so we'll move on to agenda item 10 and 11. It's the Advisory Commission update and then the briefing. So as far as the advisory commission goes, per the statute, the board had requested the advisory commission to begin studying and ultimately making some recommendations around the regulation of consumption lounges. Last week at its meeting, the Cannabis Advisory Commission passed unanimously among the members present 3 sets of recommendations around public safety, public health, and social equity as they pertain to consumption lounges. This was after over 13 public meetings between the CAC and its subcommittees. So now the board and board staff will take these recommendations into consideration as it drafts the first iteration of consumption lounge regulations. And that process is ongoing now. The goal from staff is to have that draft to the board and then be able to put it out following our normal process for first informal comment and then a formal workshop in mid-December. I'm just going to take the opportunity to underscore the importance of input from the industry, from stakeholders and the public on the front end. Once we begin these workshops, again, hopefully in mid-December is our first one, but we are hoping for robust participation in that process. So with that, Chair, I'll just answer any questions on the Advisory Commission before moving on to my brief report.
Members of the board, do you have any words of wisdom you wish to convey to our director as to what we received from the Advisory Commission? Chair Douglas, for the record, I went through what was provided to us. Appreciate the work that they did in putting these recommendations together. Some of them highlight the difficulty and the intricacy of working these into regulations. We received it, we're not bound by them, but they give us some feedback and information into things that were of concern to the Advisory Commission as we look to draft regulations for consumption lounges. It's not on for a vote, but just anyone else wish to weigh in or have any other statement?
Yeah, Mr. Chairman, I would just echo your comments that these various committees did a lot of heavy lifting initially for us, and I appreciate that. And I do note, as you said, that we can already see there's areas where they couldn't agree on certain concepts that they tend to agree on, but what are the details? So now it'll be time to dive into that part. So those are my only comments.
Member Durrett or Dr. Young, any questions?
No, thank you so much.
None for me, thank you.
Great, and just for the public's awareness, the recommendations are, the first draft of the recommendations are posted online under the Cannabis Advisory Commission page. The formal recommendations that were sent to the board, which are not too much different, only include some additional comments that happened at the Advisory Commission member. Those would be posted shortly on the Advisory Commission website as well, if anybody would like to take a look. All right, and moving into the Executive Director's report, a short one today, given our short turnaround for this board meeting. Chair, you had asked at the last board meeting to do a little information gathering around the Electric Daisy Carnival, the event that happened at the Speedway. You'd read some reports on some of the felony arrests and the DUIs, but I think you wanted a general understanding of what law enforcement saw, some of the substances. Not to put words in your mouth, Chair, but I think what you're leading up to is some conversations we're likely going to have around events, given some of the recent legislation that was introduced last session, and where we might be headed following consumption lounges, at least having those kinds of discussions around cannabis and consumption at events. We had great conversations with law enforcement. We obviously enjoy a good partnership there. The arrests varied widely. They were not necessarily cannabis related, but a lot of the stats and the information came from those arrests. So basically the substances individuals had on them when they were arrested. And that data is interesting. It obviously, top to bottom, A to Z, there was quite a few substances at EDC that they found, cannabis included. But I think it lends to a greater point, and something that we'll need to keep in mind if we do have those conversations is, the risks of polysubstance use, whether that be different kind of drugs, alcohol, cannabis, those combined. So we'll need to keep that in mind, ways to mitigate those issues as we have discussions around events and cannabis consumption at events, if we anticipate that's where we may be headed. So I appreciate you prodding us to have those conversations. There'll be more to be had on that, something that we'll keep in mind now as other events come up, work with local law enforcement, and certainly be prepared with that information and to have those conversations moving forward. So Chair, with that, I'll turn it back to you for any questions.
No additional questions. Does that comprise your report, or do you have anything else?
I do not have anything else.
We note item number 12, our next scheduled regular meeting of Cannabis Compliance Board is set for December 14th, 2021. And any of our members have items for future agendas that they wish to voice under item 13 at this time. And if we have nothing at this time, if we would have our final public comment of the day under item number 14.
Great. It looks like we have at least one public comment here in Las Vegas. Please state your name for the record.
Good morning, Chairman Douglas, members of the board, Director Klimas. For the record, I'm Kimberly Maxon Rushton, appearing on behalf of RSR Analytical Laboratories. Chairman Douglas, this pertains specifically to item 7, which was the consideration of regulation 11.015. As the board may recall, back in June when this matter was published, or the regulatory language was published, RSR submitted a request for clarification of the basis for this. Understand that your counsel has provided that to you, but as the interested party that requested it, we would certainly like to have a response to the basis of this. In addition to that, and in direct response to Member Durrett's comment, we did submit alternative language for the board's consideration in July, which has never been published or provided to the public until today. Again, the objective is that when you open up a red workshop, members of the industry and interested parties are allowed to opine and to submit alternative language or recommendations if they so choose. However, in this instance, even though it was submitted, it appears that it was not provided to the board until recently, and it also was not provided to the public so that they could offer input on the alternative language. For purposes of the record, the alternative language specifically came from the Nevada Gaming Commission's regulations pertaining to independent testing labs. It more adequately describes the standards of impartiality and that must be met, and acts that otherwise would constitute a lack thereof. And it properly puts the onus on both the cultivator as well as the independent testing lab in order to ensure that impartiality. So again, in direct response to Member Durrett's comments, I would offer for the record the fact that we did submit alternative language and assume that as part of the workshop process, it would be considered and deliberated over by this board. And as always, I'm happy to answer any questions that you may have. And recognizing again that it's public comment, but noting the fact that again, this information has been on file with the board since July of 2021.
Any board member wish to weigh in?
Chairman, just a brief comment, just in general. I just want to clarify that.
Member Durrett, I apologize. This is Ashish from the AG's office. We can't engage in public discussion and comment. It's just comment at this time.
Our counsel has spoken as to this. Thank you for your comment.
Great, and I don't know the answer to this, but what board members have before the end of the meeting any chance to add anything to the record after this agenda item?
Typically, we would ask that we agendize another matter at a later time so that board members could then properly provide comment at an agendized time.
Sounds great. It's great to learn something as well. Do we have any other member of the public in Las Vegas wishing to provide public comment today? Okay, we will go to Carson City. Chief Gilbert, is there anyone in Carson City wishing to provide public comment today?
There's no public comment in Carson City.
Right, with that, Chair, I'll turn it back to you.
With that, we are in adjournment.